Welcome to my channel. This is Bruce the Boss, and here in my home state of Texas, they're set to pass Senate Bill SB 7, which is an enhancement on voter laws, or should I say election laws. And according to CNN and other mainstream media outlets, if you were to ask them, this is the most shameful and the worst bill that is only going to restrict or suppress votes. So here's a CNN article bashing the legislation. Let's see, New York Representative Hakeem Jeffries is criticizing the bill, restrictive voting bill moving through the Texas legislature as shameful, as if we want to hear anything about what's coming from New York regarding what we're doing here in Texas, considering how much more successful we are. You've lost congressional seats we've gained due to population increases while y'all are losing. So that says a lot about what you're doing in your state. But as I'm going through this article, I see a lot of criticism and claims of voter suppression with zero to no facts about what's actually in the bill. There's no reference to what the bill proposes or what the legislation proposes, what it does, or any compare and contrast, or even opinions like, okay, this is what it says in the bill, this is why we are opposed it. There's nothing, just an opinion, and yet this is not an opinion piece on CNN. This is literally the news perspective, which I feel as though it says a lot about the bias in the mainstream media and where they lean on things. By the way, don't forget, before we get into it, don't forget to subscribe to this channel, like this video, comment on this video. Your interactions go a long way with, I guess, going against the YouTube algorithm that is actively trying to suppress any and all channels that aren't part of the mainstream media. Even larger channels like Tim Pool is getting suppressed in favor of the CNNs, the ABC, CBS. So your interactions go a long way with helping support independent content. So let's take a look at the actual bill, shall we? So here I have the law pulled up on the Texas legislation website in its full text for Senate Bill 7 that is ready to be signed. This is the status as of today, May the 30th, 2021. So let's go into it to see if there's any merit to the opinion of a lot of these mainstream media outlets, shall we? All right, so making my way through this article, let's see, election code is amended to say, let me just get to the important pieces, because I didn't really see anything myself that pertained to voter suppression, or as I thought. So for instance, let's go down to Article 2, voting by mail. It talks about here, Section 2.01, that solicitation of ballots by mail applications is prohibited. The early voting clerk may make no attempts to solicit a person to complete an application for an early voting ballot by mail, whether directly or through a third party. They're basically saying, all right, you're not going to go looking for early voters. If they want to vote early, they need to come to you. You can't go trying to solicit or encourage people to do something that they weren't already going to pre-plan to do. I don't see the voter suppression there. Let's see here, continuing on, Section 2.02, the applicant for a mail-in ballot to be voted on by mail must make this on the grounds of disability and must require the applicant to affirmably indicate that they are unable to enter into a polling place without need of personal assistance or injury, therefore justifying the need for why they're doing the mail-in ballot versus in-person balloting. I see no issues with that. If you really want to vote and you're unable to, that's okay. I don't see the need to continue the expansion of open-ended mail-in ballots for those who are capable of coming into the mailing place. What need is there for a person to vote by mail anymore if they are physically capable of coming into the polling location? There is a vaccine out there for those who are truly scared of the Modella virus right now, despite the 99.9% survivability rate for most people under the age of 40, or even in their 40s for that matter. If they are that concerned about it, they can get the jab and or wear a mask still on top of that, even after getting the jab. So I don't really see the problem with it, especially given that there are a lot of issues when it comes to mail-in ballots and being able to verify the authenticity of said mail-in ballots. I did a video on Nashawn Garrett. You can take a look at that video later on. So there's a lot of issues with mail-in balloting. I don't see any problem with limiting mail-in ballots to those who are just strictly incapable of physically appearing at a location. What is the justification for it? Even when you look at our other countries across the Atlantic Ocean, like France, for instance, we always say, look at what Europe is doing. Look at what France and the UK or Sweden is doing in terms of a lot of their progressive socialist program. Well, let's also look at what they're doing with their mail-in ballots. It's pretty much prohibited because logically it's hard to really verify who this ballot is coming from. Let's limit that capability to those who absolutely need it. That's not suppression. That can only be viewed as suppression to me for someone who's trying to game the system. If you can physically get into a mail-in polling place or to an actual polling place to vote, I don't see how that's considered suppressing the vote by not being able to just vote at home. And for those who really care about the system and want to participate, it should mean enough to them if they are physically capable of doing so to go vote in person. So let me know in the comment section if you disagree with that. Then we have section 2.03 here, which talks about how those who work for the state are prohibited from pretty much soliciting or requesting early voting ballots or applications from those who did not ask for it. So it goes hand in hand with section 2.01, just two subsections earlier, about soliciting early voting applications. So basically, stop looking for early voters where there aren't none, or stop trying to encourage individuals who had no predisposition to vote early or no prior need to. It's the same as trying to sell. If an individual needs to vote early for whatever reason due to their vocation and or business, what it is they do for a living, and or if they're military individuals who know they're about to be deployed in the weeks or days leading up to an election day, they know who they are. If it really matters to them, they will go out and vote early and or seek an application themselves. Knowing this in advance, no need to actually look for some or try to encourage those to vote early who did not have the predisposition to do so. All right, so we're moving down a little further here. We have section 2.05, which basically says those who are applying for mail-in ballot application must also be able to prove that they are disabled, whether it be a certificate of a licensed physician, chiropractor, or accredited Christian Science practitioner. So essentially, they must prove that they are disabled. Again, going to an earlier subsection of this law, in order to request a mail-in ballot legally, you must prove that you are physically incapable of getting to a voting location safely. Well, I don't see how it's voter suppression to be able to prove what it is you're saying, because we all know people can lie. It takes really nothing to say, yeah, I'm disabled, check off that box. Where's the verification? Where's the trust? You're assuming most people are honest and trustworthy and will not commit any kind of fraudulent action. We know that does not necessarily exist. You need to have safe measures. How is that voter suppression to ask someone to prove that they are somehow disabled? Most of them will be able to have that information without much delay, especially if you are receiving disability payments from Social Security already. That should be easy enough to provide the documentation and proof for. Again, unless if you're trying to game the system, but I want to know your thoughts in the comment section. If you disagree with me on section 2.05, we're not going to go through this whole legislation, but I have a few other points I wanted to take a look at. So moving right along through this legislation here, let's see here. Section 2.07 talks about the election code is amended to say pretty much signature verification. There will be a signature verification committee that will compare all signatures on each carrier envelope certificate except those signed by a voter with a witness. So essentially they're saying, okay, we're going to do signature verification unless if that signature was already verified by a witness who saw the voter do it in person. And they're also stating in here that that committee will also match those signatures against those of the voter that they have on file. So the committee may also compare the signatures with any known signatures of the voter that they have on file with the county clerk and or voter register to determine whether or not the signatures are that of the voter. Tell me in the comment section again, how's that voter suppression or trying to suppress the vote, keep people from their right to vote, by just verifying the signature with anything on file. And also, to further elude confidence in the system, any person on this committee who does not believe that the signature is that of the voter has to be a majority decision, right here. So determination under this committee that the signature does not belong to that of the voter must be made by a majority of the committee's membership. So you just can't have a rogue individual of the committee saying, oh no, I don't think this is right. What they're stating must be supported by other members of the committee to do their own independent research into the issue, look at the signatures on file and verify it themselves, not just take someone by their word. That sounds pretty credible to me. But again, if you disagree with Section 2.07 about there being a signature committee verifying and cross-verifying, I should say, signatures of voters on the ballot versus what they have on file for that voter, if that's somehow suppressing a legal vote, where am I getting it wrong? And then backing up that ability to suppress a vote where the signature does not match must be made by a majority decision. Tell me if I'm missing something. Almost done now. Moving right along, Section 3.03 gets into, let's see, amended as a watcher is entitled to observe any activity conducted at the location in which the watcher is serving. A watcher is entitled to sit or stand near enough to see and hear the election officers conducting the observed activity, except as otherwise prohibited in this chapter. And a watcher may not be denied free movement within the location at which the watcher is serving. And this is very important because this was an issue during the 2020 general election, as we saw in many cases, like in Detroit, where poll watchers were actually kept out of the room from allowing to be not only kept out of the room, but in many cases in Detroit, the election officials literally put them in another room where there was a window or a mirror, a window, and they boarded up the window, preventing them from seeing anything. In Philadelphia, there was an example of a poll watcher on video, and it was all captured on video, was literally kicked out of a polling place. Despite having an order in hand, they wouldn't let him in the building at all. In fact, one of the lawsuits that made it in Pennsylvania all the way up to the state Supreme Court, where they were challenging the over 600,000 ballots that were counted without meaningful access to the ballots, basically saying we weren't allowed to observe. Well, when it made it up to the Supreme Court of Pennsylvania there, the judge asked, well, were y'all in the building? They said yes, but we have all of these signed affidavits stating that we were kept as much as 100 feet away. The judge said, well, there's nothing in the law of the state of Pennsylvania that says that a poll watcher must be within a certain amount of feet of the of the election officials, so we're denying your case here. That's what a lot of people don't realize, is that a lot of the courts rejecting or denying cases had nothing to do with the facts or the evidence being presented by the opposition, but rather they were just trying to abdicate their responsibility. And that was the one that made it all the way to the state Supreme Court. Well, in this case, and that defeats the whole purpose of a poll watcher, because your whole ability as a poll watcher is to be able to watch, to observe. But how can you observe anything happening meaningfully as it pertains to these ballots from 100 feet away? I'm pretty certain that if I were to just go, maybe 5 feet away, you could not read what I have going on in this Twitter feed right here. Can you see what I have going on in this Twitter feed? I'm like, that was just probably 4.5, 5 feet away. Were you able to see what I was reading through my Twitter feed there? Well, how is a poll observer from more than 20 times that distance able to actually verify names and or signatures and or valid ballots? How are they supposed to really observe from 100 feet away? So this bill actually enables or allows a poll observer to actually do their job. Again, how is that voter suppression? By allowing a poll observer to actually observe what the election officials are doing, especially in some cases where I believe it was, like, for instance, in Atlanta, at the arena. Was it the State Farm Arena, if I'm not mistaken, where they actually literally had a lot of the poll observers so far over into the corner, they couldn't see what those people were doing there at all. They had no view of what was going on, what ballots were being scanned in, were they valid ballots. So this fixes that. I don't see how that's the problem, especially considering we saw that there legitimately was a problem with poll observers being allowed to actually do their job. And let's see here, moving right along, section 4.02 goes into further clarifications and, or should I say, further enforces what was written or talked about in section 3 as it pertains to poll watchers. So here we have it say an election officer commits an offense if the officer knowingly refuses to accept a poll watcher for services whose acceptance is required by this code. So basically they're saying you're committing a felony and or you're committing an offense that can calls into question the election itself for that particular polling location if we have an instance where a poll watcher has been denied access. Again, this is going to the case in my birth city of Philadelphia, where it was caught on video. A GOP poll watcher was literally denied access to a polling location. They didn't care what documentation he had to prove his validity as a poll observer. They said, no, you're not in. So this goes ahead to protect that because, again, it looks shady, especially from people who are trying to say there's nothing nefarious going on here. At the same time, don't peek behind the curtain. We're keeping this kind of close-knit. That doesn't really pass the smell test. Section 4 goes on into further. It does mention what was mentioned in an article regarding an individual's right to protest or contest an election. It talks about election fraud, and the following section of the code then addresses what an individual has the right to do. However, it does state here in section 232.062, the standard of being able to contest is that the contestant must prove an allegation described by section 2.32.061 by a preponderance of the evidence. So you can't just make an allegation. That allegation must be backed up by some proof, whether or not that includes eyewitness testimony that is then further backed up by a signed affidavit, which we saw thousands of pages of sworn affidavits in this past general election that was just ignored. But those are considered evidence in the court of law, and I would think that you would take a sworn affidavit with a great deal of credibility to at least open an investigation into potential allegations of fraud, because that individual, by signing that affidavit, that is a legal document that does allow them to be persecuted under perjury laws, which come with a 20-year sentence if they're proven to be fake or a knowing lie that is not supported by the actual evidence. So they're literally putting their life on the line, their freedoms on the line, signing affidavits that don't bear fruit. So those should be counted as evidence, I would think. And so that it does need to be a standard of proof or evidence, even if you don't have the smoking gun in hand, but rather evidence, even if that also includes one's own audit or independent audit of information that can be supported. So, but I don't see there being anywhere in this law that allows a person to just willy-nilly make a unfounded claim, which was a popular term used. There must be evidence. So I see a lot of holding up of the confidence of the voting process in this law. Let me know in the comment section. Again, if I missed anything in here that suppresses any valid or legal votes. I'll put a link to this site and this legislation in the description box below. Go ahead and check that out for yourself. I always want to encourage you to read and interpret for yourself. I just wanted to lay out all of the facts of the law as I saw it and or found it, absent of any political bias on any site. Let me know again if I missed anything. Be safe this Memorial Day weekend, or Memorial Day for those watching this on Monday. This is Bruce the Boss Brooks, and I'm out. Peace.